we don't want to pay these plaintiffs this kind of money. So you then create a separate company for the sole purpose of declaring bankruptcy and making sure that the tens of thousands of other plaintiffs get scraps.
The proposal that we had would never succeed and would not have succeeded but for the support of the claimants that had made the proposed resolution. We went to
I have no idea
bankruptcy
what you're
court.
saying. I thought it was plaintiffs who sued you that went all the way to the Third Circuit where they said you couldn't do what you're trying to do. Thank you, Mr. Chairman. Mr. Haas, if I could just come back to you. Let me ask you about the Ingham case. I'm sure you remember that case. That was the one litigated in my state, in the state of Missouri. 22 plaintiffs who alleged that your baby powder caused ovarian cancer. By the way, didn't the FDA find that there were traces of asbestos in your baby powder?
The FDA outsourced to a lab that found asbestos, a trace amount of asbestos in one lot, and 150 studies thereafter were done of that batch and found no asbestos. And if there was asbestos in that...
Okay. That's quite the word salad. But if we just compress, I think the answer is yes, right? Did the FDA find that there were traces of asbestos in your baby powder?
No,
yes.
ultimately...
No?
Ultimately,
the Third Circuit got that wrong? I just read it in their opinion.
Ultimately, if the...
Wait. Answer my question. The Third Circuit was wrong about that? I just read it in their opinion. They said the FDA found traces of asbestos in your baby powder.
The FDA outsourced to a lab that found a trace amount of asbestos.
Okay,
Thereafter,
so the answer is yes. So let's go back to the Ingham case then. I think it's a relevant question. Do you remember what the verdict was in the Ingham case, where the jury found what they awarded?
As the chair properly stated, it was initially $4.6 billion for a consolidated trial of 22 plaintiffs that was reduced thereafter to $2.2 billion.
$2.24 billion finally on appeal. That's a lot of money. That's one case, 22 plaintiffs, 20 at the end of the day because of the appeal. You were facing how many additional cases after that?
We have thousands of cases.
Thousands, tens of thousands, right?
That's correct.
Okay. So one set of plaintiffs gets $2+ billion. You have the potential for, by that math, tens of billions more, right? Who knows
No,
what?
not necessarily, because recall, most claimants lose and receive zero.
So what you do is, after the Ingham case, your company panics, and what you do is you then decide, oh my gosh, we can't possibly do this. We don't want to pay these plaintiffs this kind of money. So you then create a separate company for the sole purpose of declaring bankruptcy and making sure that the tens of thousands of other plaintiffs get scraps.
The proposal that we had would never succeed and would not have succeeded but for the support of the claimants that had made the proposed resolution. We went to
I have no idea what
bankruptcy
you're
court.
saying. I thought it was plaintiffs who sued you that went all the way to the Third Circuit where they said you couldn't do what you're trying to do. You're saying that you're saying the plaintiffs wanted this? They like the Texas two-step? The plaintiffs want to be denied their day in court and denied recovery?
The majority of claimants, counsel representing the majority of claimants, yes, do want this resolution because most claimants receives nothing.
Let's talk about what
That was an aberrant
Let's talk about what you
verdict.
did. First of all, I think it's outrageous, the idea that plaintiffs want to be denied their day in court. That's why they took you to court. That's why the Third Circuit ruled against you. Let's talk about what you did. Here is, according to the Third Circuit, an abbreviated version of how you tried to avoid actually paying out liability. Old Consumer, which was one of your subsidiaries, merged into Chenango Zero LLC, a Texas limited liability company, wholly owned subsidiary of J&J, with Chenango Zero surviving the merger. Chenango Zero then effected a divisional merger under the Texas Business Code by which two new Texas limited liabilities were created, Chenango 1 and Chenango 2, and Chenango Zero ceased to exist. Then Chenango 1 converted into a North Carolina limited liability company and changed its name to LTL. Chenango 2 then merged into Curahee Holding Company, the direct parent company of LTL. Curahee survived the merger and then changed its name to Johnson & Johnson Consumer Incorporated. Are you here to tell us that you think that this is a great way to proceed and is fair to the consumers who had asbestos in their baby powder?
Indeed, the claimants after that transaction had access to more recourse than they did before, which is exactly
more recourse.
Which is exactly
you
the reason.
created, in the words of the Third Circuit, you created a company with the sole purpose of sending it into bankruptcy. So you could limit your liability. Here's what I don't understand. Johnson & Johnson is a hugely profitable company, isn't it?
This is where we're talking about a subsidiary.
Oh, I know,
It was
but
in a
you own them
lost
all. You own them
position.
all. So aren't you hugely profitable? I mean, how much money did you make on the COVID vaccine, for example?
Nothing, actually. We made nothing.
You got
on
billions of dollars in subsidies from the federal government. Taxpayers have paid you billions. How much did you make on opioids? All those opioids you prescribed? How much did you make on that over the years?
I do not have that information.
Really? I thought it was curious when you said that your company credo was to always put the public first.
It is.
Was that what you were doing when you were lying to doctors and patients about the addictive nature of opioids? Is that why your company agreed to billions of dollars in settlements with states and other localities because of what you did to further the opioid crisis?
We prevailed in the only 2 cases that were tried. and
You
the
settled
jury
for billions of
determined.
dollars, and I brought one of those suits, and it's the proudest thing I ever did as Attorney General of the state of Missouri. Your company has made billions of dollars on American consumers, multiple times lying to them. And the idea that you now are looking actively for ways to limit the liability for further torts you have committed against the American people, I think is outrageous, absolutely outrageous. And if you want to know why the American people don't trust huge corporations, it's because of companies like yours. And I would just say to my colleagues, if you want to know why private rights of action are so darn important and why we need to use them against the big tech companies, this is the reason why. One jury verdict got $4.6 billion. That's a hammer. Companies fear it. They fear it. It's why they're trying to distort the bankruptcy code to avoid it. We need to give more Americans the ability to get that recourse in court. And we need to change the bankruptcy code to make sure that companies like J&J can't avoid it. Thank you, Mr. Chairman.
Thanks, Senator Hawley. Senator Coons.
Thank you, Mr. Chairman, and thank you for this hearing and for the opportunity for us to examine some of these issues. I'll transition to a topic I understand hasn't been thoroughly explored, but that also has the potential consequence of plaintiffs being...
Senator Kennedy.
Thank you, Mr. Chairman. Mr. Haas, you're with Johnson & Johnson, is that right?
Yes, sir.
How is that stakeholder capitalism working out for you?
How is it working for Johnson & Johnson? It's one of the greatest honors of my life.
Okay. I see where you, Johnson & Johnson, has joined with a number of other good American companies, J.P. Morgan. He's not a company. Mr. Colin Kaepernick on his issue of police brutality. Procter & Gamble, Facebook, Apple, y'all pledged $50 billion to, quote, be a force for social change and fight injustice. $50 billion is a lot of money. How is that commitment consistent with what you're asking us to do here today?
Sir, I'm not aware of the particular commitment you're referencing, but I could
It's right
say
here on the
dispositively.
internet. It's got to be right.
I could say dispositively that the consistency is, in the end, to ensure that each and every act that the company takes is consistent with our credo. Okay. And our credo puts the public and our patients first.
Right. Let me ask the professor a few basic questions, because I'm still learning about this issue. Johnson & Johnson took it, before I do, I forgot to ask you one question. How many talc cases have you tried to verdict?
There have been 42 cases that have gone to verdict. Of those, we have prevailed in 32.
Okay, so you lost 10.
Yes.
Okay, and what were the total damages in the 10 that you lost?
The damages ranged dramatically.
Just give me a total.
I don't know the total. I can give you a approximate. The highest one was in the billions.
Okay. All right, Professor. I don't want to just pick on Johnson & Johnson, but they're the one here. Let me pick on Georgia Pacific, okay? I don't want to pick on anybody. I'm learning on this issue, but let's call them Corporation A, gets sued with respect to mass torts. They spin off the liabilities to a shell corporation, and that shell corporation files Chapter 11 bankruptcy, right?
Sure.
Is that legal under the bankruptcy code?
Is that legal? The code does not restrict that necessarily. Courts have found that there are a variety of bases to reject that sort of action. So courts have been pretty active in this space. I should probably, Senator Whitehouse
what's
left.
The consensus? I mean, some bankruptcy judges say this is a legitimate use of the bankruptcy code, I presume. Other bankruptcy judges say, no, it's not, and it's dismissed. Is that a fair statement?
That is a fair statement. I think that there's a nuance here. If you don't mind, I can flesh it out a little bit.
What's the national consensus on this?
I think the national consensus is that this is a proper action under state law, but to the extent there is some sort of impropriety, bankruptcy court judges are very well positioned to police that, as we've seen in the LTL case. So it's not that Senator Whitehouse pointed out that I was supporting Texas two-step. I'm not supporting Texas two-step. I'm merely providing that
so
to the extent there is malfeasance,
the
it can be addressed.
To say this is an abuse of the code, right?
Exactly.
And
courts can address that.
How many have done that?
Well, the most prominent one is LTL. So in the Third Circuit now, there's a very rigorous test.
Is there a split among the circuits?
There is. There is. So the Fourth Circuit, and we were talking about forum shopping earlier, that would encourage forum shopping. Absolutely.
Okay. Is there a case before the Supreme Court to resolve this?
No.
I bet there's one coming. I mean, and what are you asking us to do today? Let me start with Mr. Haas again. What are you asking us to do today?
The ask from our perspective to Congress would be to make uniform that very issue you just identified. What is the standard with respect to dismissing a case? Now, there's a distinction between the propriety of a Texas two-step, let's call that, it's a divisional merger statute, and the question of what is a standard that you apply when you dismiss a case. Our case was not dismissed because of anything to do with the Texas two-step. Nobody challenged the Texas two-step in our case. In fact,
Mr. Haas, you just had a golden opportunity to answer my question. Let me ask you, Mr. Parikh, and you didn't do it. Professor, tell me what you think we should do today. What you think Congress would do.
I think there are very large issues here. I think, as I mentioned before, 524G needs to be amended to capture all mass tort cases. Once that's done, you can have uniformity in process and procedure with all these cases. Some involve asbestos, some don't. The code can be revised to provide clarity on whether third-party releases can be part of a plan. I think that would be very helpful. And then, of course, the future claimants representative. If that could be modified, have some more integrity in that selection process, those pieces together, I think, would really improve the process.
Thank you. Thank you, Mr. Chairman.
Ms. Knapp.
Thank you for inviting me to be here. My dad, Ed Chapman, died from asbestos cancer caused by asbestos found in drywall products that he worked with in the 1970s. He and a small group of other workers, about 10 men in total, worked on many projects together using the same products and tools. At least 3 of those men died from mesothelioma, a cancer so rare that generally only 1 in 100,000 people get it. These men have been wiped out by asbestos. The asbestos products that killed my dad were manufactured by and sold by Georgia Pacific and other companies. Georgia Pacific knew that their product was incredibly dangerous, but continued to sell them. In 1971, Georgia Pacific's secret internal documents acknowledged workers would get sick from asbestos and that they would sue Georgia Pacific. But Georgia Pacific didn't care. Instead, in the same documents, they callously announced a plan to blame these men for their own cancer. My dad taught me that we are all accountable for our own actions. When my dad got sick, he hired lawyers to hold these companies accountable for his sickening him and for killing his friends. Dad was able to sue some of the companies like Union Carbide and the Florida court system. Other companies like United States Gypsum were actually bankrupted by their asbestos liabilities years before my dad had claims. So he still claimed against the trust and tried to get some of the money that was left. Georgia Pacific, though, is not bankrupt. but they got a free pass. They filed the Texas two-step, forcing the victims to compromise their right to a jury trial and to accept a reduced settlement in the bankruptcy court. My dad chose to fight. He refused to go along with the blackmail, and he died without being able to see justice. Georgia Pacific filed its bankruptcy before my dad got sick. The stay that was put into place protecting Georgia Pacific has remained in place for over 6 years. Meanwhile, it has been business as usual for Georgia Pacific, which has paid $5 billion in profits to Koch Industries, while the victims have received nothing. When my dad's case went to trial in March of 2020, all the defendants that had not settled were in the courtroom. My dad was too sick to be able to attend, and he was isolated, but the lawyers and I were in court. This was literally right before COVID shut down the courts, but my dad had very little energy and couldn't really be exposed to a lot of people, so he stayed in the hotel. All the other companies negotiated settlements. This was the best he could hope for because there was no magic wand to make the cancer go away. Georgia Pacific has gotten away with letting people die. My dad died an excruciating, horrible death that he did not deserve. In the meantime, Georgia Pacific's bankruptcy, he never got a chance to see any kind of justice from them. To make matters worse, the delay will likely mean that Georgia Pacific and Koch Industries escape any accountability for what they did to my father, which is a windfall for Charles Koch, who is already the 20th richest person in the world. Under Florida law, if an individual is harmed but dies before their trial, their claim for pain and suffering dies with them. Even if Georgia Pacific's fake bankruptcy is thrown out, Georgia Pacific will argue that my dad's estate has no claim. And make no mistake, my dad was brutalized, had an agonizing suffering and a humiliation from this asbestos cancer. My husband and I cared for my dad during the last months of his life. I can personally attest to the horrible experience that my dad suffered. It is wrong that Georgia Pacific continues to try to dodge accountability. When Koch Industries bought Georgia Pacific, it knew Georgia Pacific's asbestos products had sickened and killed thousands of Americans. That didn't stop Koch Industries because Georgia Pacific is a massively profitable company. Bankruptcy is for people and companies that can't pay their bills. These Texas two-step fake bankruptcies have turned the bankruptcy courts into a sham where profitable companies go to avoid responsibilities they are fully capable of paying. America was founded on the principle that all men are created equal, but the reality of the Texas two-step bankruptcy is that they allow huge profitable companies to delay or avoid entirely taking responsibility for their actions. My dad was my hero. He was a devoted husband. While my dad was struggling with his asbestos cancer, his wife, my stepmother Ruth, developed pancreatic cancer. It was devastating to my dad. He was struggling for his own life, and now he was trying to take care of his wife that was dying. My dad never quit taking care of himself, and he never quit trying to take care of Ruth. But slowly the cancer consumed him. Seeing them through to the end was important to my dad. The fact that Georgia Pacific, with all of its profits, was effectively immune from responsibility frustrated and confused my dad. How could a company that was massively profitable, whose products you see in nearly every bathroom, every office, every building, every restaurant, every school, file for bankruptcy? And how could the rights be put on indefinite hold due while Georgia Pacific sends billions of dollars of profits to Koch Industries? It pains me to know that this abuse of this bankruptcy system has been now copied by other massively profitable companies like Johnson & Johnson. This is wrong. Asbestos products have devastated American workers and their families. When profitable companies file for bankruptcy for the express purpose of avoiding juries by stranding sick Americans in the bankruptcy system, while the companies continue business as usual, that's abuse and it needs to stop. My dad was a fighter. He saw things through to the end. My dad was not my biological father. He married my mother when I was an infant, but he's the only dad I've ever known. And I couldn't have asked for a better dad. Right before he died, my dad drove himself to the Okeechobee County Courthouse, and he legally adopted me. While that never mattered to me, he was my dad no matter what, it did matter to him, and he was going to finish the job of being my father. And he made sure he finished the job. Dad taught me to speak up against injustice and abuse and to hold myself and others accountable for their actions. And Dad taught me to see things through to the end. I am here to honor him by continuing his fight, by seeing it through to the end and making sure that Georgia Pacific doesn't get away with this abuse. I ask you to do the same. Thank you.
Thank you, Ms. Knapp, for telling us about your dad and reminding us at the heart of this issue that we are debating is not a bankruptcy code, but a real human being who lost their lives because of exposure to asbestos and simply were trying to find their day in court. Thank you very much for that. We now will go through the rounds of questioning of 5 minutes by each senator. Mr. Haas, I understood bankruptcy in a basic form to say you're a company and you have more debts than you have assets. And you go into court and say, I want to be discharged from this debt, prepared to pay whatever I can, and I want a fresh start. So I take a look at Johnson & Johnson and say, does that fit in this situation that they would go to bankruptcy court? In October 2021, when LTL first filed bankruptcy, Johnson & Johnson had a market capitalization of approximately $420 billion. 2022, year following LTL's bankruptcy filing, Johnson & Johnson generated $94.9 billion in sales and $63.9 billion in profit. September 2022, Johnson & Johnson announced a $5 billion stock buyback. Johnson & Johnson paid a dividend in every quarter since LTL declared bankruptcy, returning even more money to shareholders. You've dismissed the claims against you for a possible asbestos in your product, calling them meritless, junk science, one-off and beyond that. And yet you put a valuation through LTL of $8.9 billion in these claims. How can you have it both ways? How can you be a profitable corporation worth that much money and say these meritless claims were worth $8.9 billion and you shouldn't be responsible for them? Turn the microphone on, please. Microphone. Thank you.
The entity that sold and manufactured the talc was Johnson & Johnson's Consumer Inc., and it was in a loss position in 2020, the year before the LTL entity went into bankruptcy. So JJCI could have gone itself into bankruptcy. This is not a story about J&J. It's a story about JJCI, Johnson & Johnson's Consumer Inc. In the transaction that we undertook in order to create LTL and to place LTL in bankruptcy, we actually provided the claimants, the talc claimants, with more recourse, more assets than they would have had we not done the transaction if JJCI as the enterprise had gone into bankruptcy alone. So what we were able to accomplish is two things, which were, as the Third Circuit recognized, the objective of the bankruptcy code. One is to optimize the recourse available to claimants, and the second is to make sure that viable enterprises can go forward to the extent possible.
There's something missing here. Why would you create LTL, which made no products whatsoever, but simply was there as the repository of some funds for any liability, if in fact the underlying company that made this product in question, the company was worth so few assets at the time? It doesn't follow. Let me ask you another question. I think I read somewhere that your company, Johnson & Johnson, has changed the formulation of their baby powder over the years. Is that true?
Johnson & Johnson Consumer Inc., the subsidiary, changed the formulation to take talc out and use cornstarch instead. And they did that in 2020 because the demand for talc had gone down because of the advertising by
potential liability in a tort suit?
Excuse me?
It had nothing to do with your potential liability in a tort suit?
No, to the contrary, as we stated at the time, it had to do with the demand that had decreased due to false and misleading advertising by the plaintiff's bar. And that is at core what is the issue here. These claims are meritless, but nonetheless, even though they're...
Meritless, but worth $8.9 billion.
The $8.9 billion was an amount that we did not come up with. It is a number that the claimants came up with. The counsel for the vast majority of claimants approached us with an offer. And they approached us and they said, if you are willing to pay $8.9 billion, we will take that. We claimants will take it. And that's why we went back into bankruptcy, because we did so with written agreements from counsel for the vast majority of claimants.
Vast majority of claimants, which of course means that others who wanted their day in court for establishing their own recovery wouldn't have that chance.
In bankruptcy, in order for a plan to be confirmed, you need, for this particular type of plan, you need a supermajority of plaintiffs, not just a vast majority, but a supermajority. And that plan needs to be confirmed by the bankruptcy court. So that plan would have been approved only to the extent that the supermajority of claimants and the court determined it was the right thing to do. Our intent going into bankruptcy was to simply let the claimants and the court decide whether or not this was the appropriate resolution, because again, this was a plan that came to us, that was proposed to us as a resolution that was in the best interest of claimants. And the reason for that is twofold. One, we were winning the majority of cases in the tort system, so most claimants get nothing, absolutely nothing from litigating tort system. Secondly,
you make two arguments here. Meritless, claimants get nothing. They will recover nothing. And yet somebody comes up with a figure of $8.9 billion and you jump at it.
right, and that is...
You have it both ways. You just can't argue both ways. You went into bankruptcy court to limit the liability of Johnson & Johnson, CI or Johnson & Johnson. And luckily, at least at one or two different levels, the courts have said, this is a sham. This is a maneuver in the court which is not anticipated by the bankruptcy code. Senator Graham.
Finish your thought, Mr. Haas.
Thank you. The bankruptcy court, in dismissing the second time, actually encouraged, and that's the words of the court, quote, strongly encouraged, and, quote, urged us to continue the process, to go forward with the bankruptcy negotiations, and to go back into bankruptcy to get it done. And why? Because the claimants supported the plan. So even though the bankruptcy court recognized that under the Third Circuit's novel new standard, which is different than every other circuit court in the country, the bankruptcy court said, nonetheless, you should go forward and do it because it's in the best interest of all claimants. And in the end, that is the key. Because if you're in the tort system, most of the claimants would receive zero, and it would take 3,000 years to have adjudicated the cases that had been filed at the time of the bankruptcy, let alone the additional thousands that had been added thereafter. So the only way to get an equitable, efficient resolution was through this process. And you asked, why would we spend $8.9 billion? Litigation expenses. There are hundreds and millions of dollars being spent litigating meritless claims year after year after year after year. And yes, there was a desire to put a stop to that. And the way to put a stop to that was in the best interest of all parties, two claimants, was the proposed resolution they made.
Thank you.